So welcome everyone. It's great to have you all here at this 4IP Council's webinar called Inventorship and AI, Defining the Human Role in Patent Law. My name is Axel Frazzini, and I'm the Managing Director of 4IP Council. I'll be your host today. So simply, as you may know, 4IP Council is a not-for-profit organization, and we focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you have a lot of content. That's where you can find free materials, such as studies, summaries of relevant papers, recordings of webinars, and we have a podcast series, interviews. On the podcast, we are now featuring an AI special, where we had the pleasure of interviewing Professor Noam Shentov, one of our speakers today. You can already find this podcast episode on the website. We also produce easy to digest content for startups and SMEs that you can find in the corner that is called the SMEs Corner. That's especially tailored for non-IP experts. We have recently redesigned and updated this corner. So I invite you to go visit, and if you have any feedback, please let us know. We have also created a new area that is called IoT, or the Internet of Things, and cellular standards made simple. That's where you can find and learn about the benefits of standards and IoT across different sectors. Check it out to learn more. You can also follow us on X, LinkedIn, YouTube, Instagram. Our handle is simpler. That's 4IP Council. There you can find about IP news, resources, interviews, and the future webinars, as well as the recordings of all the past 4 or 5 years of webinars. But without further delay, it is my pleasure today to introduce our speakers, Professor Noam Shentov and Eli Pish-Yalama. Professor Noam Shentov is a professor of intellectual property and technology law and deputy head of the Center for Commercial Law at Queen Mary University of London. He lectures in the areas of intellectual property, creative industries, and technology, and his research interests are also focused on those fields. Eli Pish-Yalama is Principal Director, Patent Law and Procedures at the European Patent Office in Munich, Germany. He is responsible for all patent law and procedures related matters under the EPC and PCT, including operational developments, simplification, and digitalization of the procedures, as well as policy aspects related to patentability. A final remark for you all. Please do not hesitate to use the Q&A tool that you can find at the bottom of your screen to submit your live questions. That's easy to find. That's the Q&A tool. And all your questions will be taken during the Q&A after about 25 minutes of presentation. Noam, the floor is yours.
Thank you. Thank you very much. So thanks very much to 4IP Council for organizing this event, and particularly to Axel for taking the initiative and putting together what I'm sure will be a fascinating discussion. And today's topic, as Axel explained, is well, it's a bit odd to say it in English, but quite topical. I believe that quite a number of jurisdictions may find themselves faced with this question in the rather near future. So defining the human role in patent law, and more particularly, what is the level of contribution required from an inventor in order to, level of contribution required from a person in order to qualify as an inventor under patent law, particularly in the context of AI assisted or generated, whichever terminology you choose to follow, inventions. Now, we know, and that has been the case for a long time, that our patent systems around the world require and the applicants to designate the inventor in the patent application. You just have here four provision to that effect. As I said, dozens and dozens of jurisdictions around the world, the vast majority would have a similar requirement. So we need to designate the inventor when we apply for a patent. We also know now, post-DABUS litigation, and I assume that we are all familiar with the DABUS litigation, that when designated the inventor, one needs to ensure that one does not designate an AI system. So post-DABUS, it has been made explicitly clear that an AI system would not do in terms of a designation of inventor. Judicial decisions to that effect, US, UK, Australia, Germany, of course, the EPO, Haley would probably expand on that, South Korea, and more. So an inventor needs to be designated. It cannot be an AI system. So it needs to be a natural person. Now, what does a natural person have to show in order to reach the relevant threshold so as to constitute an inventor under patent law under such circumstances? Now, we have two explicit statements on that point of law that were made rather recently in the last year, which I will actually look at, and one jurisdiction where no explicit statement to that effect it was made, but where I believe the situation or the legal position perhaps, I wouldn't say clear, but there's some indication as to where we may find ourselves, and on this I'm referring to the UK. And two explicit statements, both in Germany and in the United States. And in the United Kingdom, we go way back to actually the DABUS Court of Appeal iteration as early as September 2021, where some judicial statements to that effect on that point were actually made. I'll come back to those briefly at the end of my presentation today. But let's start with the United States. So that was last February, so a little bit less than a year ago. The USPTO decided to clarify things and to explain what kind of contribution is expected from a natural person, so that that natural person may constitute an inventor under patent law, particularly in the context of AI-assisted inventions. And what the USPTO did was to come up with, or to explain that the test, or the relevant test for that purpose, is significant contribution. So AI-assisted inventions may be patented if a natural person has made a significant contribution to each claim in the application. So our human agent, if you would like, in the process must have made a significant contribution. And for that purpose, they refer to a ruling of the Federal Circuit from 1998, the PANU decisions, and more particularly the three PANU factors. For reasons of brevity, I won't go into the PANU factors here, and perhaps we don't have to, because the USPTO went one step further and actually provided guiding principles on the application of the significant contribution criterion to AI-assisted invention. And this is what I would like briefly to focus on when I look at the position in the United States. Now, these guiding principles are 5 in number, so we have 5 guiding principles. I will focus on 2 specifically, which I consider to be somewhat problematic. Now, if you look at guiding principle 3, the USPTO explains that reducing an invention to practice, by the way, I did not explain before that the PANU decision has absolutely nothing to do with AI, and the PANU factors have nothing to do with AI. It is usually, up until up until the era of AI, these questions were relevant when we needed to decide whether it was person A or person B who were the real inventors. So deciding between who is the rightful inventor or the correct inventor between a number of options. Now, going back to the USPTO guiding principles in relation to AI-assisted inventions, the USPTO explains that reduction to practice alone is not a significant contribution, but then they go on also to explain that a natural person who merely recognizes and appreciates the output of an AI system, if that appreciation is obvious, apparent is the term that they use, but obvious to the person skilled in the art, such a contribution is not a significant contribution, and therefore such a person will not be considered as an inventor for the purposes of patent law. So let's think about that for a second. You control an AI, or you engage with an AI system in invention making process. You observe the output of the AI system. Merely recognizing the significance and utility of this output is not going to be enough. What the USPTO suggests here is that you appreciating its significance and utility must rise to the level of not being obvious to the skilled person or apparent to the skilled person for that to be considered a significant contribution. So a little bit confusing. That's a kind of exercise that one would expect to face an inventive step type of assessment rather than an inventorship type of assessment. The USPTO goes on to explain that if you actually observe the output of the AI system and you put on top of it some considerable contribution, then you may actually count as an inventor. But just recognizing the significance and utility is not going to be enough. Now, why do I focus on that? I focus on that because in the past, and I prepared a study on the question of inventorship for the EPO in 2017. It was out in 2018. And one of the things that I looked at there was that in most, if not, most patent systems around the world, you can come by an inventive process by sheer luck. The quality of your inventive effort is less relevant for an inventorship inquiry. What you would need to show is that as an inventor, even if you can buy the inventive concept by sheer luck, the only thing that you will need to show is that you have recognized its utility and significance, and that would be enough. Nobody would ask, well, hang on for a minute. Was it as a result of an inventive effort or a spark of genius rather than sheer luck? No, even if it's sheer luck, it would be enough for you to recognize what it's worth for you to count as an inventor. Then, of course, you'll have to face the inventive step inquiry at a later stage. The USPTO appears to suggest that that is no longer the case. Just recognizing and appreciating the output as useful, right? It's not sufficient. It needs your appreciation need to be non-apparent to a person of ordinary skill for you to be considered as an inventor. What the USPTO also went on to clarify is that what was considered to be the criterion for inventorship in the US, actually up until 2018, which is intellectual domination, that in my view is very sensible in the context of AI inventions, AI-assisted inventions, is not sufficient. Now, intellectual domination over the process in which AI took part, even a significant part, is not sufficient. Now, let's let me clarify here, intellectual domination rather than financial domination or administrative domination. We know that financial domination, administrative domination were never sufficient, but intellectual domination is not enough. They're looking for something more. Simply owning or overseeing and prompting an AI system is not going to be enough. They want to see something more. Again, I am not suggesting that such questions are not necessarily relevant. My point, as it will become clear perhaps later on, is that they are relevant, but should be relevant at a later stage, and that is at an inventive step inquiry rather than an inventorship inquiry. So, implications of the US PTO guidelines or guiding principles is that we may end up with a situation where we have an AI-assisted invention that has clear societal benefit, right? And it is created, is not easily replicated or hardly can be replicated by any competitor. So there is an interest in protecting it. A natural person maintains intellectual domination over the process, but when the AI output, which is highly relevant for the invention, its significance and utility is apparent to the skilled person, such intellectual domination over the process, the appreciation that this output is highly relevant is not going to be enough. What we need is something extra, and that is that appreciation must be not apparent to the skilled person. The same applies for an input that prompts an AI. If that is an exercise of normal skills, that is not going to be enough for you to be considered as an inventor. And under such circumstances, it's not only that we say that, or we determine that a person may not be considered as an inventor. The ramifications are that such invention stays outside the ambit of patent law. In other words, rather than the traditional inquiry, when we employ those tests and we say, well, you know what, it's actually Noam that is the inventor rather than Axel. What we are saying here, no, Noam is not the inventor, and therefore no patent protection for such an invention, irrespective of any inventive step inquiry that may be taking place down the line, right? So such an invention or such innovation may prove to be completely non-obvious under the inventive step inquiry, but we don't even go there. We just say, well, Noam hasn't done enough, he is not an inventor, and under such circumstances, there's no protection. And when it comes to critique, I mean, it's more than those 3 points. I'm actually working right now on a paper that addresses this question specifically with Dr. Francesca Mazzi. But the 3 lines of critiques are that there is an unnecessary conflation of the concept of obviousness with inventorship, that it potentially may deny protection of worthy innovation that warrants patent protection when we think about the public policy objectives of patent law. And it also in the US may encourage validity, unnecessarily encourage validity challenges, where people may challenge the validity of the patent on the basis of whether or not a human inventor was involved in the process. And I therefore believe that it is actually the German approach that manifested itself in the recent decision of the German Federal Court of Justice from last June, where the German court made it very clear what we need is a person who significantly influenced the AI system. If you wonder what significantly influence means, the German court went and clarified that there will always be a human inventor sense, and that's a quote. There is no such thing as a system that searches for technical teaching without any human preparation or influence. You have prompted an AI system, you have looked at its output and appreciated its significance, should be more than enough. You are the inventor, we are not going to have the issue of such innovation staying outside the scope of patent protection. And that leads me to the last bit of my presentation, very briefly, in the United Kingdom. Now, I said that in the United Kingdom, the court did not deal with this question explicitly. But when you look at the scaffolding of the patent system within the United Kingdom, we see a number of things. Sure, the inventor, for the first thing, the inventor is the deviser, actual deviser of the invention, the inventive concept. Who is the deviser? Actually, Lord Justice Richard Arnold in DABUS helpfully referred to the Oxford English Dictionary definition of a deviser as a person who devises, a contriver, a planner, right? So someone who plans the process and engage with AI, an AI system within that process may be our inventor. But whatever we think about what exactly a deviser, the definition of deviser covers, from a practical perspective, it is of little significance in most cases. Section 13 tells us that the applicant needs only to nominate the person who they believe is the inventor. That's it. If that's what they did, if they nominated a natural person who they believe is the inventor, the nominated norm, that would not be challenged by, for example, by the examiner or the controller. So by the patent office. What about any third party? The only person that may challenge that nomination, say, of me as an inventor, is a person who believes to be themselves entitled to the patent. So if the applicant nominated me, Axel may challenge that nomination and say, no, actually, Noam was not the inventor. I am the inventor. I am the inventor, and so therefore I'm entitled to this patent. But you cannot have a situation when I seek to enforce a patent against a third party, like you may have in the US, and that third party says, you know what, that patent cannot hold because Noam's patent has nominated the wrong person as an inventor. So in other words, for practical purposes, we are not likely to come across any significant issues that this legal question may give rise to. So in terms of my final thoughts, and when I look at the two schools of thought in that respect, what we can find in the US and what we may find and what we see in Germany, in my view, and I think it's pretty clear from my presentation, brief presentation, the German approach is much more sensible. Where we actually engage with the quality of the invention at the novelty and inventive stages. But for the purpose of inventorship, as long as the natural person has been involved and engaged with the AI system as part of the invention-making process, such a person is likely to be the inventor, and such innovation may be protected under patent law altogether. Thank you very much, and I'll be happy to take any questions at the end of this session. Thank you.
Thank you, Noam. Now it's my turn. So good afternoon, everybody. My name is Heli Pihlema, as introduced by Axel earlier, and I would like to give a short overview of the patentability, inventorship, and AI-generated submissions for AI in the patent system in general from the perspective of the European Patent Office in the ALIA. So Noam was already referring to the notorious, as he said, DABUS cases. And for the European Patent Office, we actually, our legal port of appeal was the first legal instance, so the first judicial instance to take a final decision on the DABUS cases. What, according to the European Patent Convention, is important here is that Article 60 of the European Patent Convention makes it very clear that the right to the invention belongs the right to the invention and the right to the European patent. So the right to the European patent belongs to the inventor or to the successor in title. So patent is a right. And what our legal board of appeal, when it came to the conclusion that the EPC requires that the designated inventor is always a human being, it also referred to the very natural fact, very practical fact, that AI systems do not possess any rights. So therefore, because the right to the patent belongs, so an AI system cannot have a right. And also, when we talk about successor, if the AI system would be the inventor having the right, of course, when they don't have any rights in the society, because the rights and obligations belong to persons, therefore they couldn't even transfer the right to anybody. So the legal board of appeal, its conclusion that the designated inventor needs to be a human being, it confirmed the approach taken by the European Patent Office when dealing with the applications. Noam already mentioned some of the final decisions that have been taken in the famous DABUS cases. There has been also decisions from appeal instances in New Zealand, Taiwan, and patent authorities have decided, for example, in Canada, Brazil, China, India, Israel, Japan, South Korea, and Saudi Arabia, that the inventor needs to be a human being and AI system cannot be inventor. For the European Patent Office, when you file a European patent application, so the European Patent Convention requires that that there is an inventor designated, and that the inventor designated is then a human being. And if there are any disputes later on about who should be the inventor or whether the human being is the correct inventor, those are within the competence of national courts, because the applicant is deemed to be entitled to exercise the right to the European patent. So the applicant has the entitlement, but needs to designate the inventor. And of course, the requirements for designating a human being as an inventor, that applies to every single inventor who has contributed to the invention, which way ever. And so the designation of inventor is taken by the European Patent Office at face value in those cases, and disputes then for the national offices. Of course, when we then look at the later consequences that might be there, we have to take into account all the patentability criteria that applies, because in the sense of patent law, the invention can exist in all fields of technology. But to be a patentable invention, which is as such not defined, it needs to be new compared to the state of the art, needs to be inventive, so not obvious for the person skilled in the art, and susceptible for industrial application. AI-related inventions are usually computer-implemented inventions. As a rule, that applies, at least what we see from the practical, empirical point of view. Some inventions, some patentable inventions, are excluded from patentability, including programs for computer, if claimed as such in the application. The European Patent Office applies following a decision G119 pedestrian simulation of the Enlarged Board of Appeal, a so-called two-hurdle approach. Namely, if the invention is run on a technical device. So then the middle section here is overcome. But then when we look at the inventive step assessment, we can only take into account features contributing to the technical character. And so only the technical the features contributing to technical character, so the technical features as such, can be taken into account when it is looked whether this is then obvious for the person skilled in the art or not. And of course, then we come to the question, what kind of skills the person skilled in the art possesses. Just a very small excursion to show one example about how this is. So in the case of, can be in the case of artificial intelligence and machine learning. So technical application and then the specific technical implementation, which is then what is the technical there. So the mathematical measures that could be in there to serve the technical purpose and, for example, the control of technical system or process, they are technical. They are then also taken into account for assessment of inventive step. But when we look at the AI-related inventions and the patentability requirements, of course, then the question is, when we look only at the technical features, what is obvious to the person skilled in the art? So there we have also to see who is the person skilled in the art. In the application implementation of the European Patent Convention and in the case law related to it, so it is clear that the person skilled in the art can be even a team of persons, and it can also be expected that the person skilled in the art uses some devices, some tools like AI in order to achieve, to devise the invention. What is in this context and also sometimes discussed is that, okay, can it still be described, the invention, in a way, in a manner that would be sufficiently clear and concise for the person skilled in that to carry out the invention, because that is also a patentability requirement. And if AI is used, is it then, would it be something that is hidden? But of course, that is, as I said, patentability requirement, that what is done with the help of AI needs to be described in a sufficiently clear and concise manner that somebody else from the same field who is also using AI as a tool in that area can then potentially carry out the invention. Of course, there are all the further requirements, procedural and formal, that need also be taken into account and to see what is then obvious to the person skilled in the art in that case. I was already mentioning something about AI as a tool for the inventor, for the person skilled in the art, when we refer to the patentability requirements. Of course, AI is also a tool that we, EPO, as the patent office, are using to enhance the efficiency of the patent grant process, for example, classification and search. And but there, what is important for the European Patent Office and in the context of patentability, and of course that is also the part there behind the aspect of human being needing to be the inventor, and also the aspect of rights, that in Europe also the European Commission and European Parliament have in all their actions and in the AI Act stressed the human oversight and development and development and use of AI, because there is the human-centric approach that is important there. Of course, AI offers also AI tools offer opportunities for inventors, as I mentioned, but also then for the applicants when they search the prior art or when they file their patent applications. And there has been also from some patent authorities guidance how that is to be seen for the European from the European perspective or from the perspective of the European Patent Office. It is very clear that towards us, the content and its merits, not the origin of any submission matters, but there is always the human being who is submitting anything towards us, who bears the responsibility that the submissions are accurate, and there is a duty of care and duty to cooperate in the proceedings, and not to say, okay, this was drafted by AI and therefore the mistake somewhere in the description of the patent, for example, was an oversight. More information can be found in the guidelines on examination. The next edition will be in April 2025, republished on the EPO website in February 2025. And with that, I would like to give back to Axel and happy to take any questions.
Thank you very much, Lily and Noam, for the presentation. Let's get started right away with the questions. The first one is, how does the use of AI, the innovative processes, alter the concept of the person skilled in the art? Maybe that's a question for Eli.
Thank you, Axel. The concept of the person skilled in the arts, like many other concepts in patent law is in many aspects of it really a very old creation, but it has been drafted in a way that it is adaptable to any technological developments. Therefore, for example, the person skilled in the art, the concept has been there for decades, hundreds of years, we can almost say already. And of course, the concept is what it is, but how it is applied, how it is implemented, what do we understand under person skilled in the art, that develops together with the technological development. You can say, okay, person skilled in the art. Today, we have collaboration everywhere. So you need to have advanced knowledge in this technological area, different technological area. So you can take a team as a person skilled in the art. And of course, you can expect that somebody who is person skilled in the art is also skilled to use the tools. So we can expect that somebody in those areas of technology where AI is a common tool also uses it. And so therefore, it is just the natural adaptation and natural development of the concept of person skilled in the art that is linked with AI at the moment.
That's very interesting. But then a quick follow-up question that we just received among all the questions received. Somebody says, do you think that there will ever come a time in which AI will be granted legal personality due to its potential increase in ability to invent autonomously? What would the implications of AI possessing legal personality then be?
Axel, I will jump before Noam, even though I expect that Noam would also like to say something about that. One of my repeated statements is that patent system is also only a part of the legal system in the society. There is not the possibility to think about rights and obligations or legal personality for AI in the scope of patent system only. Because of course the implications would be going much further. As I discussed earlier, patent is a right. And therefore, in the legal system, in a democratic context. That would need to be seen in a larger context, like the European Commission and European Parliament have been discussing AI Act and the human-centric approach. And of course, everywhere the question, can you give a computer system, an AI system, a software program, rights and obligations would be needed to be answered in a larger context before we talk about that in the patent system.
I can just chip in here. And first of all, I completely 100% agree with Heli on that. So I subscribe to the view that such a question should not be viewed through the lenses of patent law. Anyone who is interested in that question, actually, there has been an attempt maybe to consider it. I think as early as 2016 at the European Parliament, and in response there was an open letter from experts both in law, technology, philosophy that challenged this invitation to consider. I think the terminology was electronic personhood. To my mind, sure, we don't have a crystal ball, but I cannot foresee this being relevant anytime in the foreseeable future, unless we get to a point where we have an AI system which is, has consciousness. I mean, if that's the case, patent law is the least of our worries. We have much bigger worries then, because, as Heli said, legal rights and obligations, we do have it with corporations, but this is something completely different. We always accept that there are people behind the corporation. Behind the corporate veil, there are people, and we can always reach those people if something goes completely wrong. But the whole reason or justification for having AI as having its own legal personality is that it's autonomous of any person. It doesn't add up, at least where we are now technologically and beyond that. So that's my take.
Very good. Maybe a question far from this topic, but more for Noam. You made a reference to Germany, and so the question is, what do you believe the German approach in this context is preferable to the US approach?
Okay, I perhaps didn't have enough of an opportunity to explain it during the presentation. So whatever you may think about the merits of the significant contribution threshold in the United States as a test to determine who is the inventor, and that perhaps warrants a completely different discussion. It has been used and it has been considered originally in the context of deciding who is the rightful inventor, whether it's A or B. It is problematic when we apply it to AI-assisted inventions. Because if we agree that we wish to encourage innovation that is new and non-obvious, right? We don't have any moral objectives to the particular invention and so on, then I believe that the German approach actually delivers. Because we find an inventor in the process, always, at least for the foreseeable future. And then we assess the quality of the invention, as Heli explained, for novelty and inventive step, and if it is justified, then a patent is granted, right? If it's obvious to the skilled person, we are not going to have any patent. Otherwise, there's a clear interest for us as a society to incentivize the creation of innovation, which is novel and not obvious. In the United States, we may end up with a situation where an AI system, say, I'll give you one example. Let's say that I develop an AI system in-house. It's not part of the state of the art. I develop it in-house. When it produces an output, which maybe once you have access to this AI system, maybe the significance of this output is actually obvious to the skilled person. under the US guidelines, guiding principles, since the output is obvious to the skilled person, such output, this obviousness would render the human, or the human agent here, the person, as a non-inventor, and the outcome of that would be that we don't have a patent in the end of the line. Well, in fact, if you would have left this investigation to an inventive step level, the inventive step phase, you would say, well, whatever it is, whether it is obvious or not to the skilled person at the point in which they have access to the output, I need to actually ask whether this output would be part of the state of the art. And if it is not part of the state of the art, that it is worthy innovation, that we do want to incentivize such innovation, because it's not likely to be repeated by a competitor. That's one of the main objectives behind our patent system. And I think that the US approach here loses the bigger picture in that respect. Those questions are highly relevant, but an inventive step level, not an inventorship level.
And that sounds very good. Maybe a tricky question for Eli. So just suppose that somebody is filing a patent application with the EPO, and you have two options. The person may say that they may claim that the invention described in the specific patent application was devised by AI, and AI should be an inventor. What would be the EPO reaction? That's the first part of the question. Second part is, what if somebody files a patent application with the EPO without declaring that actually the patent application was, so the innovation was created by an AI? They don't disclose it at all.
So for the EPO, as for the European Patent Office, as I mentioned earlier, a human being needs to be designated as an inventor in the application. And then, so we require that the human being is designated, of course, in which function that human being and how the human being has contributed to the invention. That is not what we at the European Patent Office check. In case there is somebody claiming that this is not the right inventor, such disputes would be then a matter of the national courts of our contracting states. And therefore, we take the applicant, we take the inventor as face value, as long as there is a human being designated. If somebody then starts court proceedings about that fact, then we would put the application in hold and wait for the decision from the national court before processing that patent application further.
Very good. And for you, Noam, what do you think a UK court will be likely to decide on the question of the level of human contribution to qualify as an inventor?
Oh, well, I first of all, I would hope that the UK would land close to Germany in that respect. I can tell you where I don't think that it would land, and that's close to the US. I maybe prove wrong, but if we look at the terminology used in UK patent law, we look, as I said, there weren't any explicit statements on that in the DABUS litigation, but some statement made by various judges, so whether it's Law Justice Beers or Law Justice Arnold, who referred, as I said, to the Oxford Dictionary definition as a contriver or as a planner. Perhaps it would not go as far as the German approach, where it appears that it may be sufficient for you just to pull down the liver of the AI system for you to be considered as an inventor. But I think that a planner, so as long as you prompted an AI system, you considered its output, whether or not that is obvious or not obvious to the person skilled in the art, I do not see the UK court going that far. And if that is the case, then the point is that you almost always, if not always, would be able to identify a human inventor. And this is very important because it means that such innovation potentially always stays within the realms of our patent system, and then is going to be assessed whether it is novel or it is not obvious, which is exactly what we want.
One question received is raising the possibility that various approaches of particular countries having different, level of different thresholds for the level of human contribution can just pose some challenges, like international trade, for example. Would it be possible to have like an harmonization? Both of you may not have the same opinion though. How to harmonize this? How to make sure that everybody would have the same level?
I don't know who should Heli?
No, Noam, you start, please.
Okay. So I think in that respect, perhaps it would be useful to distinguish between EPC member states and the international scene as a whole. I think internationally, we already see that there is disparity between Germany and the US, and to some extent, there always has been. Not ideal, but whether we can have because we don't have harmonization on the rules, patent rules overall, we have TRIPS, but it gives us, it's obviously not about a complete harmonization or anything like it. I think that perhaps it's more important to consider it in an EPO context. Now, as Heli explained, the determination of who and what do you need to show in order to be considered as an inventor is decided at a national system level. So the EPO would like to see that a natural person is being designated, and other than that, who is the right or the correct natural person is to be decided at a national level. I think there is a lot of value. There may be a lot of value in discussions among EPC member states for that purpose. Because again, I want to emphasize that this is not the traditional question of whether it is Heli or Noam who are the rightful inventors. This is what we are deciding here is whether it is a type of innovation that comes within the ambit of patent law. Because if we find that Noam did not do enough, let's say in a country like, I don't know, Sweden, then there is no patent. Even though the innovation in question may be new and not obvious. Do we want to see that at an EPC level? In my view, at the EPO level, or EPC member states, in my view, it's not ideal. And therefore, even though not as a matter of strict law, but having conversations between EPC member states would be very valuable in this context.
To complement just what Noam said there, of course, there are already now, since actually 2016-17, the EPO started to initiate the discussions with other international patent offices and patent authorities and also judicial institutions about AI and patents, and also about the inventorship question. And we are also continuing the discussions with our contracting states on that, so that there is at least, of course, every court is independent. They have their judicial independency to take the discussions, but at least we try to contribute as much as possible to raise awareness of the different aspects, and that this question exists everywhere. And therefore, also other patent authorities like the USPTO, Japan Patent Office, Korean Patent Office have been active in initiating discussions, as well as WIPO as well. And so there is wish from everybody to contribute and to make sure that that we don't come to a situation where there would be big international distinctions about this question. Axel, you're muted.
Well, one related question that came up is related to the DABUS decision in South Africa, in Canada. And the question is, I know that you don't have a crystal ball, okay? But do you believe that South Africa made the decision may change their mind and may try to align with what you have explained in your, and the question says, in your great presentations?
I might take this. So in South Africa, there is a registration system where there is no check. So it's what is submitted is taken over in the register of the South African or patents in South Africa. So therefore, of course, it has not been assessed or addressed in the same way than in the other countries.
In Canada, it says that the inventor was unknown. They wrote as unknown. So what did it change?
So there, that is information that is more further than my status, where it was, which was that also the Canadian Patent Office was stating that the inventor needs to be a human being. I am not aware of any final outcome in that. Maybe the questioner knows it. I only know that there had been a request for extension to reply to the Canadian Patent Office, and therefore there has been kind of an intermediate status for a while. But I will certainly check that afterwards. Noam, I don't know if you are...
I'm not, unless it's something really recent. It sounds to me a little bit similar to what happened in the United Kingdom in the Court of Appeal at the minority view, where Law Justice Beers was inclined to agree that an applicant needs only to state who they believe the inventor is. And if they do not believe that there is a human inventor, they actually may say so. And so we don't know, but that, as we know, in the UK did not hold. So majority view was to the contrary, and then it was different. And then at the Supreme Court in the United Kingdom, that was indeed the case. But I'm not familiar with this Canadian development. Like Heli, I would go and check that after this webinar.
Okay, one last question is related to the role of the UPC. Is there any role of the UPC in any disputes on inventorship? No?
Okay. Of course, the UPC is also then to decide on patentability criteria and patentability requirements in cases of invalidity claims and infringement. So we will wait and see, not to take any position here for the UPC or on behalf of the UPC on this.
Okay, so before the conclusion, Noam, I think I noted that you have a forthcoming article or paper on this topic. When is it going to be published?
So I'm still in the I would say very close to the end. So it would be a paper by me and Dr. Francesca Mazzi. And hopefully, so again, if those the people who actually follow me on LinkedIn, hopefully it would be already out this February. And yeah, in paper form, as it usually is, it's much later. But we don't care about those things anymore these days. So as long as it's available on necessary, and that should be sufficient. So hopefully this February. So watch this space. Thank you.
Thank you so much. So this is clearly a fascinating fascinating topic, and I expect it to evolve in the next few months or a few years. But now time is up. So I would like to thank you very much for sharing your knowledge and expertise. It is really a topic that is close to my heart, that I'm following very closely. Thank you to all the attendees as well, because without your questions, that will be less dynamic. So thank you very much for attending and asking questions. A recording of this presentation will be made on the 4IP website tomorrow. And don't forget to register to our upcoming webinar on the 13th of February. That will be on the EDC IPR policy, origins, intent, and misinterpretation, explained by two creators of the IPR policy of EDC. You can find the QR code on the slide that you can see on your screen right now. And finally, I would like to remind you that tomorrow you will receive a survey. Please take 2 minutes to answer to the survey, maybe 1 minute, just to provide your feedback and maybe potential topics that we could cover in the next webinars. So Hayley, Noam, thank you so much. And I wish you a great day.
Thank you. Goodbye.